Sir, state your name for the record, please.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments. Also, Your Honor, I would like to make an offer for my appeal, if I may.
I'll get to that momentarily. The record will reflect that the individual known to this court to be Darrell Brooks is appearing in person in custody. We are, of course, outside the presence of the jury today. Since they are not here, we are dealing with some housekeeping type of issues and other legal matters. So he is appearing today in jail attire. He is in custody. And it's my understanding, Mr. Brooks, that you were offered to appear in the suit, but chose to come to court in jail attire, which is fine. We're not in the presence of the jury. I just wanted to make a record of that.
I do not consent or identify by the name that you stated earlier. I want the record to reflect that, if I may.
The record will reflect. Thank you.
Will we address the inmate communication form I sent about the...
I have a number of issues I need to address, so yes, we'll get to that.
You don't believe that has that's an important issue that should be taken up before we continue any further in the proceedings?
I just want to make sure the state has a copy of what was forwarded first before we take that up. I'm not seeing it in the record yet, so I did a F5, so it'll refresh.
So the prosecution will receive a copy?
I believe one was printed now for them. It is in the record. And then I'm going to print off something as well. I don't know if it was already.
Your Honor, I respectfully would like to state for the record and would like the record to reflect that I believe that this is an issue that should be addressed at this point before we go any further.
Preparing to do that. I didn't say I wouldn't do that. So give me a minute. I have some documentation that I'd like to provide to the parties as well.
Yes, dated today because I just learned of the protocol that I would be on as of today.
Can you print or make 2 copies, one for each party? All right, I'm going to provide a document to the parties. It's a 5-page document. It is a document that was forwarded to me at my request by Monica Paz, our clerk of court, after receiving the inmate communication form from Mr. Brooks requesting an adjournment. For the reasons stated in that document, I thought it important that we all have before us the current county protocol related to COVID-19. And so this will be provided to the parties.
Now, I decline to accept that if I don't believe
Sir,
that
it will be placed on your table, but I will be referring to that today, so it's been given to you.
Is it verified law, Your Honor?
Attorney Opper, do acknowledge that the COVID-19 illness reporting protocol was provided.
I respectfully object.
Yes, Judge.
Your Honor, I would like an answer to that question if I may. As I have not consented to or agreed to accept any paperwork that
Sir, it's been
It's
provided
not-
to you. It's
So are you
something I'm gonna
making-
consider. You don't wanna
Are you
read it,
making-
you
are
wanna
you making a
disregard it, that's
judicial-
your choice.
Are you making a judicial determination that you don't have to answer that question I just asked you, Your Honor?
Mr. Brooks, the COVID-19 protocol has been placed in front of you. It is your choice whether you want to review it or not. So my understanding, just from the information Mr. Brooks has provided, which is part of the public record, is he is requesting an adjournment of all proceedings. I wanted to make sure that I had the most recent information that at least the county of Waukesha is operating under. I also verified with court staff that the location at which you are seated is not within 6 feet of any other individual in this courtroom. Is there any other information you think I should know as I consider your request for an adjournment today?
Yes, I find it hard to believe that you couldn't consult with jail staff to verify the protocol, to verify that I was seen by nurses that
I don't have that
specifically.
information, sir, and let me be clear, cannot be provided to me under HIPAA. The only information I have is what you put in the inmate communication form.
It could be verified because I was told when I was brought down here that everybody knew that I was on a COVID protocol. That's why everybody
Because you advised us.
That's why, no, because the jail advised them. That's why they had to wear masks to bring me down. That's why I'm essentially on a protocol that doesn't allow me out of my cell until my results come back. So I'm not allowed out of my cell at the moment because of the protocol that the nurse himself placed me on, that the jail confirmed. That is very easy information to obtain.
Sir, I
Just-
have
just like-
an attorney for the
Excuse me, Your
county
Honor.
here
I
who
don't-
will
I don't wanna-
verify
I
that
don't
none
want
of
you to
that
think I'm trying to
information
argue
has
with
been
you, Your Honor.
provided to me due to
I don't-
HIPAA
I don't want you to think
requirements.
I'm arguing.
So I'm not
But I-
arguing it with you,
I
sir,
know, I
one
just
bit.
want you to know that I'm not arguing with you either, but I was right in the middle of finishing what I was saying.
So I need to stop you for a minute, Mr. Brooks,
I don't
because
consent to that, Your Honor, because
you don't have to consent,
I
but here we
don't
go. Let
consent or
me,
agree to being cut off right when I'm trying
all right,
to
I'm just
provide
gonna
the
talk
court with
over him for a
information.
minute. I do not have any other information regarding, meaning anything specific about you, Mr. Brooks. I respectfully ask for all proceedings to be adjourned at this time, which is why I asked you if there was any other information you wanted to provide me as I consider your request, because the jail has not provided me with any specific information regarding the reason you were placed on protocol, whether you were exposed, whether you are showing symptoms. They cannot provide me with that information absent you giving them permission by signing an applicable authorization to do that. Without that, I have to rely upon you to provide that information to me
that is-
if you so choose.
That is incorrect because that was the last thing I was hoping I would be told today, Your Honor. So I'm afraid right now. I'm not feeling well. I don't know what's going on with myself. That is the reason why the COVID test was administered, and that's why I'm on the protocol as we speak.
Are you willing to discuss with me what tests were done?
I
Again,
don't-
I cannot obtain that
I don't.
information on my own.
I'm not a nurse, Your Honor. I don't know the name of the test. I don't. Like I said,
I-
I've never had this
Let me
happen.
clarify that. That was a pretty ambiguous question. So, you reported symptoms as that's what you're telling me, right?
Correct.
And you're saying some tests were done?
I mean, that it's obvious. I mean, why can't it be verified with the nurse?
I have to verify it with you. The nurse will not provide me with this information.
But the jail can because they control the movement. They control all inmate movement. I can't just go from my cell to a HSU.
Inmate movement is not the issue at the
It's,
moment.
it's not, but
It-
I'm saying, how can I tell you, how can I answer what you're asking me
It doesn't make sense. We all understand that the jail itself controls the movement of the inmates. That's common sense, Your Honor.
I'm not here to talk
I
about
can't- I
inmate
can't
movement
just-
at the
I can't
moment.
just
What I'm
walk to
asking
the
you is,
HSU.
do you believe you were tested for COVID? Do you know
The
what
nurses-
type of test? Was it an oral swab, a nasal swab?
It was a nasal swab.
All right. Do you know when the results of that test will be back?
From my understanding, Friday. That's what I was told by the doctors. I would have to be at least on this protocol until the results come back, which
Were you-
he said the earliest would be Friday.
Were you offered a rapid test?
They said they do not do the rapid test.
So you weren't offered a rapid test?
They said they don't do them.
If one can be obtained, are you willing to submit to a rapid test?
I'm not willing to submit to anything right now until we take care of the issues that's at hand. I mean, I've already been placed on the protocol. Frankly, I'm very afraid right now because I don't know what's going on. This is new to me. Like I said, I'm fully vaccinated, Your Honor. I've been fully vaccinated since 2021. And so for this to just be sprung on me now to say this could possibly be a COVID thing, I've had people close to me that have passed away from COVID. I'm afraid as hell, Your Honor. That's the reason why I submitted the ICF for the adjournment. I was thinking at least until I can get the results, at bare minimum. I don't think I'm asking something that's
Sir,
impossible for Your
if
Honor
I
to
can
grant.
make arrangements to have a rapid test brought to you and administered, are you willing to submit to that test? Anything else, sir, you think I need to know about this issue as I consider your request?
No, at this time, I'm just telling you what I know. Multiple officers were there. They can tell you the same thing that I'm telling you now. Like I said, Lieutenant Chamberlain was there. 2 officers were there.
Any objection if I talk to any of them to confirm what you're saying?
Absolutely not.
Any objection if I need to ask the jail administrator about, or anyone else at the jail about the protocols and what's available for testing?
Absolutely not.
Given any information about whether anyone else in the facility is experiencing COVID right now?
I wouldn't know that. I wouldn't know who. I'm in the mental health medical pod as it is.
So no information's been provided to you that despite you reporting fatigue, I don't know if you're standing or sitting on the chair. I can't quite tell. It appears like you're standing, but maybe leaning over the table.
I got a knee on the chair.
Oh, knee on the chair. Okay, but you've been able to very clearly, coherently make your position known to the court at this time, and I appreciate that. Let me ask Attorney Opper if there's anything you would want to provide or state at this time regarding this request.
Yes, Your Honor, a couple of things. Number one, we believe this is nothing more than a further delay tactic by Mr. Brooks.
How could
Mr.
that?
Brooks, did
How
you
could
hear
that even?
Attorney Opper interrupt you when you were talking?
Well, I respectfully object to
You
that.
can object, your objection's noted, but you need to let her state what she needs to state. I will give you an opportunity to respond. I'd
That's
encourage you to use
that is
paper and a
ridiculous, Your
pen
Honor.
to write down. That's the rules of decorum in the courtroom, sir. We generally avoid interrupting one another so that, number one, the record can be clear, and perhaps most importantly, because that is a sign that we all understand that this is a place of dignity, it is a place of respect, it demonstrates that, frankly, a willingness on the participants to conduct themselves appropriately. It avoids creating disorder or disruption.
We're at 5 days right now, and certainly the court's offer to,
I never once said.
Mr. Brooks,
I never
you have
said.
an
I never.
opportunity
No,
momentarily.
No,
You
I
need to stay
respectfully
quiet.
object to that because that has no merit.
Mr. Brooks,
I-
it's not
she's
your
saying-
time
no,
to speak.
No, I respectfully object. I never reported I never reported saying what day. I never said a day. And if she's saying she has jail phone calls, well, why aren't they present? Why can't they be verified by sworn affidavit and brought into this court to be shown that this is a delay tactic, as you say it is? How come it can't be shown by sworn affidavit? Can you provide proof of that?
All right, Mr. Brooks, I've given you a little
Just
bit of
like-
leeway
just like you're
because we
saying
are outside the
that I've
presence
waived
of the
something.
jury.
I haven't given consent to waive anything. How could that be a delay tactic? If that was a delay tactic, why would I even need to be tested and placed on the protocol? Why does everybody have to have on masks to bring me down here?
All right, Mr.
Is
Brooks,
there no-
I've
is there
given
no
Mr.
verification?
Brooks, I'm going to warn you now that you have interrupted a couple of times. You interrupted
I have to
Attorney
be able-
Opper
I have to be
twice.
able to speak up,
You're
Your
now
Honor.
interrupting me yet again. We all were polite and had you provide
was not
information.
polite. That was
That's
abuse.
at least the
that was
third
abuse.
interruption of this court.
That was abuse by the prosecution. That was abuse.
Mr. Brooks, let me finish.
No, because that's
So he's outright refusing to listen.
I would
He's
not sit
outright
here.
talking over me
I didn't
at the
refuse
moment.
anything. I didn't refuse
Mr.
anything.
Brooks, we are at
I'm
the
not
point
gonna.
yet again
I'm not
where
gonna
I
sit.
will put you in the other courtroom because
And
you
I
are
don't
not
consent.
able.
I don't consent to being removed. I have not waived the right to be present, and I don't agree with that.
Mr. Brooks,
Does the
I
record
have
reflect?
provided
does
you
the-
on multiple occasions and it's should be in front of you.
No,
and
I
if
don't.
not,
I don't acknowledge that. I haven't agreed
you
to
have been
it, and I
advised
haven't
on
given
multiple
consent of it.
occasions that you need to abide by the standards of courtesy and decorum for the courts of Wisconsin. Because you are a litigant, you're both a named defendant, you are now acting as your own attorney by
I'm not a named
representing
defendant.
yourself.
I don't recognize the name
That all of the
the
rules
states
of courtesy and
put on
decorum
their
apply to
complaint. I don't
you.
recognize that name, Your Honor. That is
Supreme
not who
Court
I am.
Rule 6.
So, Your Honor, respectfully, just so I'm clear, are we addressing the issue at hand now?
We are.
Or are we addressing something from September?
Well, I will get to the September.
I said that I wouldn't have any issue with pertaining to myself. I don't know. I'm not speaking about anybody else in the jail. I'm not speaking about everybody's situation is different.
Right, and I'm specifically referring to your situation.
Well, the question was asked in, how does it pertain to me? It was pertaining to me, all the questions, which it came up when I said that there was a lieutenant and there were officers present when I took this test from the nurse.
Right, I'd like to verify the information that you're providing to me regarding what was reported by you, what tests were administered, and why you're on the protocol with the jail administrator. First of all, do you understand what I want to ask her about?
No, I do not understand.
Did you hear what I said just now?
I do not understand.
But did you hear what I said?
Frankly, Your Honor, I think she would probably be the wrong person to be asking because she wasn't present.
You must understand then what I'm saying if you think she's not the person who would provide that
No,
information.
I don't understand.
So
I didn't consent to understanding or agreeing to that. No, I do not understand.
all right. I took his statements earlier. I realize you don't have a written waiver as to be a verbal waiver of any privacy rights under HIPAA, and I am directing you to answer the question.
Okay. It was brought to my attention shortly before the lunch hour that he had made statements that prompted the medical department to follow up.
Ms. Wallenhoff, if there were different types of tests available, why wasn't I administered the correct test when I first was tested? Why would essentially I would be asked to take a test, take that test, then turn around again and be told to take a whole nother test? In my mind, that's almost like some type of ploy or something, some type of scheme. If I've already taken one test,
You have to give her an opportunity to answer, and you
I've
gotta ask one question at a time.
I just asked the question.
Can she answer it then? Do you want her to answer it? I presume you do since you asked the question, so you need to stop talking so that she can answer it, okay?
Limit your abuse, Your Honor.
I'm sorry?
I don't appreciate being talked to that way, Your Honor.
Your objection is noted. Go ahead and answer. All right, fair enough.
I did not say the wrong test. I said 2 tests. If it was, why would I need to take 2 tests for the same symptom?
Your Honor, I object to relevance and beyond the scope of this witness's knowledge, and it also assumes a fact, not an evidence.
All right, so I'll sustain the objection. I'll give both parties an opportunity to ask questions of this witness since it's Mr. Brooks's request. I know do you have any other questions for Jail Administrator Wallenhaupt on this issue at this time?
I don't think I was clear, or I didn't have clarity on the answer to that question. Why would I need to take another one?
I'm gonna object as to lack of foundation and beyond the scope of this witness's knowledge, Your Honor.
The objection is sustained. I'll direct the witness. She does not need to answer that question. Next question, if you have one, please.
I still don't have clarity on that, Your Honor. I'm baffled.
Do you have another question? A different question?
Would it be any way to verify why I would need to take 2 tests for the same symptoms?
I'm not sure I understand the question, sir. I think
I'm referring to the nurse who administered the test.
the nurse isn't here, though. This is Jail Administrator Wallenhaupt.
And that's why it's hard for me to wrap my head around why Mrs. Wallenhoff would be called to testify when she was not present. I think the wrong person is testifying.
Do you have any other
Because
questions
the
for
reason
her?
why I say
I understand
that-
what you're saying. Do you have any other questions
Are
for
you
her,
sure
though?
Are you sure you wrapping your head around what I'm saying, Your Honor?
I believe the record's clear that a rapid test was offered. It was declined by Mr. Brooks. The record's also clear that
I
he did
object to that,
submit.
Your Honor.
He did submit to a test, but this witness is not able to answer whether that was a rapid or not, given her role in the Waukesha County Jail as the administrator and not in charge of medical. I will find she does not need to answer that question because it's outside her scope. Might be speculative. So, do you have another question?
So would it be fair to say, you just said it would be speculative, so would it be fair to say that it'd be speculative that, is that an answer,
I can't
Your Honor?
answer that question at this
Well,
time,
I'm
sir.
asking it of Ms. Wallenhoff. Is it because we just said it would be speculative?
Well, you
So-
were looking at me when you said that,
Well,
so are you, and I'm not gonna answer that question. I'm not a witness in this.
The
I
reason
make
why
the
I was-
determination
The reason why I was
ultimately.
looking at Your Honor is because
Do you have another question
I'm
for
still trying
Jail
to figure out
Administrator
how-
Wallenhaupt?
I thought testimony was supposed to be the prosecution and the defense's time to ask
Sir, do you
questions.
have another question? Otherwise, I'm gonna ask the state if they have any more from this witness.
I asked the question, would it be fair to say that it's speculative?
Objection, relevance.
No, it's a question.
Hold on.
I'm
You're
getting
asking
I'm going somewhere.
I'll let you get the question out, but I would just note you're asking her a hypothetical that, given her role, she might not be qualified to answer, but you can go ahead and ask it.
Well, it's not hypothetical. It's very logical. If you were offered a test and you took it, why would you need to essentially take another test that could have been done right from the beginning? If there would be any issues, if there would be
All right, Mr. Brooks, it's not relevant what she would do. So that's essentially an argumentative
Okay, so
question,
why-
and
so
it's
why would
not
I do it?
relevant. So
Why would
sit
I do it
down.
then?
You're done asking questions because you've
So
now
is that a
asked.
judicial determination?
I haven't made a judicial determination yet.
You're
Go ahead,
practicing
Attorney
law from the
Opper.
bench by being able to ask
Mr.
her
Brooks?
questions of yourself.
Mr. Brooks, okay, here's your warning. I'm giving Attorney Opper an opportunity
So
to
you're
ask this
practicing law from
witness
the bench.
questions, and if you interrupt her, you will be removed to the next courtroom.
I don't consent to being removed to the next courtroom. I don't consent to even being at these proceedings if I'm not able to put on a proper defense, which is my constitutional right to be able to do so. I haven't agreed to any contracts. I haven't consented to any contracts, and I have
Your
not
objection
consented-
is noted. Attorney Opper, go ahead.
I have not consented
Thank you.
to
Ms.
an
Wallenhop.
estoppel either. Then I would like to put you on notice that I will be appealing that judicial decision that you are making.
Next question, Attorney Opper.
The judicial determination.
Ms.
rather,
Wallenhop.
that you are making.
While on COVID protocol, does Mr. Brooks have access to the tablets in his jail cell?
Yes, ma'am.
And that tablet has legal materials available for him to access if he so chooses, is that correct?
Yes, ma'am.
And while he is on COVID protocol, does he have access to the conference room, which also contains a computer with further legal materials?
Yes, ma'am.
And nothing about the protocol would restrict his access to any of those materials, is that correct?
Correct, ma'am.
And you've
I object to
indicated
that. I
previously.
object to that respectfully, Your Honor.
So, an objection goes to whether there's lots of rules of evidence that
That's it.
apply, but if you're objecting to her answer, that's a different thing. You can argue
I'm
the meaning
objecting
of
to
that
the
later.
question.
Okay,
not
the
the
objection,
answer.
but then you have to say objection before she answered. All right, Mr. Brooks, you have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No, I don't
It
see
has
it.
the criminal statutes.
I don't see it.
It has the traffic code. It
I
has the
don't see
rules
it.
of evidence. Well, it's on your table. It's
That- I
behind the
don't-
microphone, and it's there. I've provided it to you as a courtesy so that you have that available
You did not
to
provide
you.
anything to me.
Right, I'm
Something
directing the
that-
bailiffs to
something
remove
that
him
they
to the
have-
other courtroom.
something
I've
that-
provided ample opportunity
never-
for Mr.
I've
Brooks
never
to
taken
abide by the
anything-
simple
I've
rules
never
of
taken
decorum
anything,
and
Your Honor.
civility.
Your Honor, I don't
He is-
consent or agree to what you are doing.
Your lack
don't
of
give
consent is
consent.
noted for the
I
record.
don't give consent to an estoppel. I don't give
I'll make a
consent.
more full record when we
I
are
don't give
open
consent
again to
an
the public.
estoppel. I don't give consent to be removed.
Madam
being
Reporter, the
able
record
to
should
exercise
reflect
my
the court is
constitutional
stepping
right.
off the bench. You may step off
I
if you
move.
want.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.
Prior to the court ordering Mr. Brooks removed from this courtroom to the neighboring courtroom, there were 9 interruptions. So it was on the 10th that this court ordered him to be removed to appear remotely from that other courtroom. It is an elementary standard of proper conduct to not interrupt. Mr. Brooks repeatedly interrupts. Mr. Brooks persists in his unruly conduct. Nor can the accused be permitted by his disruptive conduct indefinitely to avoid being tried on the charges brought against him. Once again, it did not take Mr. Brooks very long to begin interrupting. It is 2:39 now as I go through this decision-making and put my findings on the record, but his behavior started very early on. I gave him ample warning before he was removed. This court, frankly, has no other option at this point other than to put him in the other courtroom so that I can continue with this very important hearing, a hearing at which he has requested an adjournment of the proceedings.
That is irrelevant to why I'm asking for adjournment. I was not asking for adjournment based on being able to utilize the conference room or a tablet.
Your objection is noted, it's overruled, or her answers may stand. Next, you may continue, Attorney Opper, with your next question. Mr. Brooks, do you have anything else related to the inmate communication form dated September 28 of 2022? Since we obviously included that after we took up the other issue.
Yeah, I'm still, I don't understand how, any questions that I was asking, are not allowed to be answered.
Mr. Brooks, I'm asking you very clearly, do you have any other information, testimony, or evidence you want to present as it relates to the inmate communication form dated September 28 of 2022?
Yeah, I would like to, is it a way that we can verify the standards of the Keep Separate Protocol?
Mr. Brooks?
To be able to show the
Mr.
court.
Brooks, please listen very carefully. There's a question I'm asking you, is do you have any other evidence?
I don't consent to being asked a question.
Document, all right,
when
then
you
I'll,
can't even answer the
all right,
question
I'm going
without
to mute
asking
him
me.
once again. He is not answering very clear questions. It is document number 244, scanned on the 28th day of September 2022, wherein Mr. Brooks was advised that the judge cannot be his attorney, cannot give him any legal advice. The district attorney cannot be his attorney, cannot give legal advice. The judge, district attorney, and court personnel are not required to explain court procedures or the law, among other things, and that he is required to follow all legal rules and procedures that an attorney would have to follow in court. He was also advised, and this is just one part of that form, that it may be difficult for him to present evidence, it may be difficult for him to do a good job as his own attorney. We discussed at length the advantages to having an attorney, the disadvantages to representing oneself. And what he is asking this court to do is to explain the law, and could also be described as a request for legal advice. All right, with that then, I'll certainly take up any arguments from the parties as it relates to both of these issues. I'll start first, though, with the motion to adjourn. Mr. Brooks is holding up the objection. That we're not taking testimony at this time, so the court does not feel compelled to acknowledge that any further, other than to say the fact that he's objecting is noted for the record. Mr. Brooks, I'm going to unmute you because it is your motion to adjourn these proceedings, and as such, I will give you the first opportunity to talk about the evidence that I've heard here today by way of testimony, and to make your specific request known to the court. I then will give the state an opportunity, and then I'll decide the motion. All right, Mr. Brooks, what is your argument as it relates to the motion to adjourn?
Well, I'm not arguing. I stated pretty clear why it should be an adjournment. I don't think I need to argue anything. I don't think I need to provide anything more. If it's clear to me that the wrong person was testifying.
Thank you, Mr. Brooks. I'm going to turn to the state then next. As a reminder, don't interrupt them. Thank you.
Well, Judge, I'm glad to hear Mr. Brooks say this is not a trial prep issue and merely his concern for the health and safety of others. The court has already made the record that we can safely accommodate Mr. Brooks in this courtroom without risking the health and safety of other individuals, even if he should have positive results on his COVID test. We feel comfortable with that as well. The jail can still move him properly. The bailiffs in the courtroom can still respond to his needs properly. So if it's merely a health and safety issue, I believe we've easily overcome that, Your Honor. I don't put much credibility in the comments of Mr. Brooks here. As Detective Regland just advised me, he made 17 attempts for phone calls just this morning alone. So his statement to the court that he was worried about being able to call his family, I think, really is questionable. I also would like the court just to acknowledge that document 258, and perhaps that's a moot issue at this point, but I still think a record should be made that no matter what circumstances have arisen with Mr. Brooks specifically in the confines of the Waukesha County Jail, he has always had access to his legal materials.
Let me address Mr. Brooks' motion to adjourn. He filed an inmate communication form earlier today, raising this issue. He is on a protocol. He is not tested positive. He provided information today that he is fully vaccinated, that he'd been telling officers for days that he had not been feeling well. We do not have the test results today. He was offered a rapid test and refused. He reports symptoms of fatigue and that he can't taste. He also indicated it was a few days ago over the weekend that he started experiencing these symptoms. Now, during his time here today, Mr. Brooks, despite the disruptions, has been very clear, coherent. I'm not going to adjourn this trial. I'd also put on the record that he has not been denied access to materials. So that is my record here. Today, I agree with the state's assessment. This is nothing more than a delay tactic. All right. Any questions about the broadcast, Mr. Brooks?
I didn't really understand the whole gist of it. So, I'll go with the part that I don't think that if you are not in the courtroom that you should be privileged to see anything. I think the word you used was graphic.
I am not responsible for Court TV's compliance with FCC regulations, but it's my understanding that they will meticulously follow whatever the regulations are. But what's in the courtroom is clearly going to be what's in the courtroom, and anyone in the courtroom will be able to see fully based upon the monitors, including the jury, including the court, and including you, whether you're in this courtroom or the next courtroom.
Yeah, that would be the preference. If you're not in court, you shouldn't be able to see everything in court.
Mr. Brooks, I wanted to invite you back into this. Oh, never mind. I do this all the time. I need my court reporter. It's kind of a small thing. Welcome, Michelle. No, that's my fault. I should have looked over there. In my defense, in my other courtroom, it's on the other side, and I got to get used to that. All right, we are back on the record then. Appearances are as they were before. Mr. Brooks, I'd like to invite you back into the courtroom if you so choose. You have been respectfully participating from the other courtroom. Of course, if you do come back in, you, of course, would be expected to abide by the rules of decorum and courtesy. Would you like to come back to this courtroom, sir?
I never stated that I wanted to be removed in the first place.
My question to you, sir, is would you like to come back over to this courtroom?
I respectfully never consented to being removed.
I will ask one last time before I consider his answer to be non-responsive. Would you like to come back over to this courtroom, sir?
That is not a non-responsive answer, Your Honor.
So the answers provided were not responsive to the question that I asked, and therefore he'll remain in the other courtroom.
The record reflect that I did not respond. I responded, it just wasn't accepted.
The record speaks for itself, sir.
Your Honor, I'm very tired, so.
Mr. Brooks, we're gonna keep going, so please don't interrupt so that we can do this as quickly as possible so you can go back to your cell.
I was just merely trying to make the record, which you have denied me to do. As I stated at the beginning of the hearing, I would like to make an offer for my appeal. I've stated that on the record numerous of times yesterday and today as well, and I haven't been awarded that right to do so.
Mr. Brooks, I'm not going to respond to that simply because if you want to file an appeal, then you should take the necessary steps to do that. All of my decisions are on the record. You can request a transcript if you want to have a written copy of what was said in court. I can't provide legal advice on how to pursue an appeal, but I would not grant an appeal. That is not within my authority. That is a reviewing court would decide that, whether that be the Court of Appeals, the Supreme Court, or otherwise. So that's why I'm non-responsive to that, is because there's nothing for me to do as it relates to that based upon the request that you have made. So with that, Mr. Brooks,
Can you verify that by sworn
Mr. Brooks, I'm
affidavit
gonna
that I
mute you,
cannot make?
okay? Mr. Brooks, you've now earned the mute button once again. Despite you saying that you're tired, you had no difficulty making objections, objecting, and once again asking for an appeal. So I need to get going on this hearing, and that's what we're going to do. I would like the state to confirm on the record whether you've had an opportunity to have the motion served on Mr. Brooks. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that Mr. Brooks's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. All parties in the courtroom, including the attorneys, the litigants, witnesses, the judge, the jurors, and those in attendance, are expected to conduct themselves appropriately and avoid creating disorder or disruption, as well as conduct themselves in a manner that demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process. I would not read the SCR unless there's a request to do so. That is there just for reference. That's where I pulled that from. There's a second part to the proposal that if at the time the court reads the preliminary jury instructions, Mr. Brooks is not in the courtroom, then to add the second where it says to be read only, that says at the moment Mr. Brooks is appearing from another courtroom, this must not influence your verdict in any manner. I think it would be good to be consistent. If I read this at all at other points in time, I will use his name that I have listed on this proposed. All right, Mr. Brooks, I'm going to unmute you so that you can put the basis for your objection on the record.
Yeah, first of all, I'd like to state for the record that I'm pro per, not pro se. And what you just said about keeping it consistent, then it's been in this form ever since it was brought up. So why start to change the language and logistics of it now at this point to constitute me being in a separate location? If it's going to be consistent, then it should be consistently as it was constructed. Nothing should be changed.
Sir, do you have, want to make any statement related to the jury instructions that I've provided to you, whether you object consent, agree, or otherwise?
No, I don't consent. I do not.
All right, your lack of, sorry, go
I
ahead.
just stated the reasons why.
Is that to
You
the
just
whole,
said so yourself, you just said so yourself, they need to be consistent. So why does anything need to be changed at this point?
as to the entire packet that was provided to you, noting I've made this change, I will,
didn't
hold
accept
on,
anything
hold
that
on,
was.
hold on. I will advise you that as to the added paragraph, I will make it consistent with the verbiage and the pattern instructions and refer to him as the defendant. However, if I have to read this instruction at other points in time, I will be reading it with the verbiage of Mr. Brooks. I do that, frankly, out of respect for him. But the pattern jury instructions are constructed in such a way that I'm going to follow that pattern when reading instructions, with the exception that I've just noted, and that is if I am in the position where I feel it important to advise the jury, whether it's just simply that he's in another location or another courtroom, this must not influence your verdict in any way, or if I feel it important to read the entire thing. So, as I understand what you're saying, sir, I think what you're asking this court is to add an instruction because the jurors get informed. Hold on, let me finish. The jurors are informed of the law through jury instructions. These are the pattern jury instructions with the exception of what I've just added to number 70, which I feel is appropriate in this case. If there's something additional, then tell me what it is, and do you have a draft to provide to the court for consideration?
Well, how about this, since it's clear that you're not grasping quite what I mean by what I'm saying. How about I draft something up and get it to you as soon as possible? Would that be sufficient for your honor?
If you draft something and submit it, and we have it by tomorrow morning, I can address that on the record, and whether it will be included or not. So yes, that's acceptable.
For the record, also may I state, and it's going back to the language that says pro se. Can that be changed to pro per?
That's not read to the jury. It's just part of the labeling. But it is my pattern, but it is the pattern jury instruction. That is a phrase that has meaning in Wisconsin law. It is accurate, and so your request to change it to pro per is denied.
Okay, how is it accurate?
That's my ruling, sir.
I don't understand, so I'm just seeking.
Mr. Brooks, that's my ruling. I need to finalize these, Mr. Brooks, I need to finalize these instructions. So my question to you is, oops, you can take that up.
No, I did have one suggestion.
Okay.
On the second.
Hold on, just,
Sorry.
Mr. Brooks, what I want to tell you is, I'm going to finalize these. The state has a suggestion for verbiage within an instruction that's already in there that I'm going to address. I'm then going to ask you whether you have any other edits or requests as it relates to them, and then ultimately ask you whether you approve of these or not. I just want you to be advised of that. So go ahead, Attorney Basie.
Thank you. On the additional language that the court is adding to jury instruction 70, I would just state on that second sentence, my job includes making sure the defendant's rights are protected. So I think that should be the.
Right there.
Yep. Or I could just read, sure, the defendant's rights, whatever.
Since nobody nobody saying anything. Part of my rights being protected would be to be able to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys. That's another right that's not being protected.
If you're requesting that that language be included, the request is denied.
And is that a judicial determination that I won't have?
I do not believe that accurately states.
Right preserved?
I do not believe that that statement accurately reflects the law. All right, so we'll make the, Mr. Brooks, I'm moving on.
Can you show me by?
Mr. Brooks, I'm gonna mute you. I'm not required to show you verification of law. Again, I direct you to the waiver of right to attorney form, a copy of which has previously been provided to you about what this court can and cannot do. That's a very good summary. If you have any other questions about what the court can and cannot do, I also direct your attention to the Supreme Court rules. My understanding is you have access to legal materials, and there are a number of rules that apply. The Code of Judicial Conduct is SCR Chapter 60. All right, we've made that change. With that change, does the state approve of the jury instructions?
Yes.
All right, Mr. Brooks, I'm going to ask you that question. Actually, two, do you have any, and you're raising the objection. Hold on, you're raising the objection sign. It's noted for the record.
I'm going to continue doing it. That's the only way I can.
No, I know, and I'm making a record of it, sir. But we're at the point in time, do you have any requests for edits? Let me finish the question, sir. You're interrupting. All right, I'm gonna have to mute him again so that I can get my question out. Mr. Brooks, my question to you, do you have any other requests as it relates to edits, other instructions, or corrections of the 69-page instructions that you were provided with? And the added instruction that you were able to see on the screen. Go ahead, you are unmuted.
I wasn't looking at anything on the screen, and I already made clear on the record, and you just confirmed on the record that I will be able to draft something up and get it to you. So why can't I address anything in that draft?
Sir, I am addressing what we have now. So I will ask you now at this point, since you've not answered my question, I understand that you're going to draft something. Other than that, do you have any other edits, corrections, or requests for inclusion at this time related to these jury instructions?
Yeah, you still haven't answered if I'll be able to inform the jury of the truth, their rights, and their duties.
Sir, I have provided an answer to that. All right, I'm going to object. I'm going to not object. I'm going to mute him again. I have told you you will have the opportunity to draft a proposed jury instruction for inclusion with this packet. At this point, he hasn't answered my question directly, and by his responses, I will make a finding that he's not responding. It's a non-response type of answer, and because I've advised him as to what I intend to do, I am going to approve the jury instruction packet that has been provided to the parties and modified on the record. My question to the state, and then will be to Mr. Brooks, is if I adopt the request from the state, do I need to put in a similar statement like what is in the hit and run about you don't need to be unanimous as to which crime he committed, but you need to be unanimous that he committed a crime?
I think that would be helpful to them. I think the paragraph before the one I just recited says the defendant is charged with violating a condition of bond that required that he not commit any crime. So I think that verbiage would be consistent with that first sentence.
Any position on that, Mr. Brooks? Or sorry, go ahead. Any position on that?
Yeah, I don't agree with why should it matter about a unanimous or not being unanimous. If that was always the case from the beginning, then it should have been changed at the beginning, not at this point where everything is so close to being decided. I don't understand why it needs to be changed in any way, why it needs to be altered in any way. I think if it was going to be that they have to be unanimous, then let it be unanimous. Let it be unanimous for everything.
All right, I agree with the state's position. I think that's the most appropriate under the law, given the violation of bail jumping. It can be a variety of different ways, but in this particular case, the state's relying upon that statutory subsection for violating any crime. So in element number 3, it needs to say the state must prove by evidence the state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree reckless endangering safety, use of a dangerous weapon, hit and run resulting in death or battery. And so that I actually took out, where it says crimes, I changed that, I took out the S as well. I think that you would need to do that, or I would need to do that in order to be consistent with the or. So I'll make that change, and then
just so I understand for the record, the jury instructions that you have are the ones that we're gonna use. I can't make a few of my own.
you can still, if you want to draft something, you have to submit it so that we can consider it, but it has to be in writing. And keep in mind, sir, jury instructions are read by the court, and they're statements of the law that I give to the jury so that they better understand their functions as a juror and the law that applies to this case. But you have until tomorrow morning to bring that to court in written form. If it's accepted by the court, my clerk will type it up and will insert it in the appropriate spot. If it's not accepted, then it won't be included.
And then, as to opening statements, I understand the court's order, you want us at our tables. Would the court reconsider that in the event Mr. Brooks is not present in this courtroom for the state's presentation of opening?
At this time, I would not reconsider because, as you know, I oftentimes invite him back in or require him to come back in, and I don't want to be in a situation where now I've let you do that, but I can't let him do that for what I think are obvious reasons to everyone.
Oh, I see, okay.
Anything else?
No, we did want to indicate that certainly we're willing to share exhibits with Mr. Brooks. If there's anything he wants displayed and it's admitted by the court, we can pull it up and be of assistance to the court and Mr. Brooks. We also want to renew our earlier offer if he needs assistance in serving subpoenas, as long as it's a relevant witness and it's a reasonable request that is limited to southeastern Wisconsin. We will give any assistance we can. We want Mr. Brooks to have a fair trial. We want him to have his relevant witnesses and evidence ready for the court. If there's something he wants, even if it's a document, we don't have the document camera, we have the entire file scanned. Or he can give it to us and we can scan it in 1 minute and have it up on the screen. So we are more than willing to do that so that we can all be efficient in our presentation. Yes.
Okay, all right, thank you, everyone. We are in recess for tonight. We'll see everyone tomorrow at 8:30 a.m.
You could let him know I'm gonna print it right now, so it can be handed to him before he.
Yep, and the bailiffs need to make sure they don't let, we need to print off material for him. It's coming forthwith. Right, thank you.
Wanna, well,
We're in recess.
Polycom's